Hello and welcome to Rights and Recourse, a program that educates you about your rights and recourse to those violated. My name is Dumile Mateza. Land ownership in South Africa has long been a source of conflict. Its history of conquest and dispossession, of forced removals and racially skewed distribution has left it with a complex and difficult legacy. The Restitution of Land Rights Act was passed in 1994 at the advent of democratic rule in South Africa and ended at the end of 1998. Its stated objective was to provide for the restitution of rights in land in respect of which persons or communities who were dispossessed under or for the purpose of furthering the objects of any racially based discriminatory laws. In July this year, President Jacob Zuma signed a bill authorizing the reopening of the land restitution process. This is Rights and Recourse, and today we are discussing the Land Restitution Amendment Act of 2014. To discuss this rather controversial topic are Professor Bernadette Atuaheni, author and professor of law at the Illinois Institute of Technology, Chicago Kent College of Law, and Tamim Donswa, Deputy Land Restitution Commissioner. Before we get into our discussion, though, let's take a look at this insert.
The colonial and apartheid governments stole massive amounts of land from blacks in South Africa. As a result, in 1994, when South Africa transitioned from apartheid to democracy, whites owned 87% of the land, although they constituted less than 10% of the population. This is just an outrageous injustice. And to make matters even worse, 2014 marks 20 years of democracy in South Africa, and less than 10% of the land has changed hands from whites back to blacks. Righting the wrongs of the past is extremely difficult, but South Africa has not given up. On June 30th, 2014, South African President Jacob Zuma signed a bill to reopen the land restitution process. My book, We Want What's Ours, highlights the successes and failures of round one of restitution so that round two can be a success. I did a documentary about one family's fight to get their land back. Till this day, they are still in the middle of their struggle. People can only wait so long to get what's theirs. There are success stories. I interviewed a woman who got her house back, and she said she was restored not only of her house, but of her dignity, her self-esteem, and her pride. She told me, at least we got what was ours. And that's what needs to happen for everyone. Black South Africans were robbed, and they need justice. The international community must stand with South Africa as they search for viable solutions. As the great Martin Luther King said, an injustice anywhere is a threat to justice everywhere.
If you'd like to join us on today's discussion, please call us on 011-714-5497 or 5498 or tweet us at Rights and Recourse. We'll be back after the break. Welcome back. Ladies and gentlemen, welcome to Rights and Recourse.
Thank you for the invitation.
As we have already said, Mr. Mdonswa, what necessitated this new amendment, the reopening of the land claim?
As you've already said, Mr. Mateza, the Restitution Act was signed in 1994. It had a cut-off date for people to lodge claims, which was 31 of December 1998. So immediately thereafter, after the cut-off date, people started asking government to reopen the lodgement of claims. The matter was discussed extensively at Parliament and in the Land Summit that was held in 2005. And eventually in 2009, when the previous administration took over, people still echoed the call that government must open. They said in the previous allotment period, the communication campaign did not reach everyone, so not everyone knew that they could lodge claims. And as a result of that, then we then started the process of having the law that was signed in July.
But even then, you could never have done good work with processing all the claims. 63,455 claims, by 2000 only less than 5,000 were processed.
Between the period 1994 and about 2000, claims could only be settled through the Land Claims Court. So it was a judicial process, and there were amendments that were effected in 1998, allowing for administrative settlement of claims by the minister. So between the period 2000 and 2008, we then saw an increased pace in the settlement because of the powers that were given to the minister to settle claims.
Bernadette, what made an American girl wanting to write the story about land restitution in South Africa?
Well, I'm a property law professor, and my specialty is actually issues of land and land injustice. And so my first encounter with South Africa is in 2002, when I graduated from law school. I came to the Constitutional Court of South Africa to clerk with Justice Ngobo and Justice Madala. And that was my first introduction to South Africa. What made me want to write the book is in all of the different conversations about land in South Africa, the focus is almost purely on rural claims. And so with my book, I've done 150 interviews of people evicted from urban areas. And the point of the book is to open the discussion up to also talk about urban claims, because 1/3 of the beneficiaries of the land restitution process, of the land restitution program, were in fact urban, but yet we have almost no conversation about these urban claimants. And so this is one of the objectives of the book and of me writing the book.
Well, earlier today, before we start the program, we spoke about Mr. Mdonswa and the minister were down at District 6 in Cape Town, which is a very controversial area of the kind of things you're talking about, urban removal of people because of the Group Areas Act.
Absolutely, and the District 6 is actually one of the communities included in the sample for the book. So I've spoken with people from District 6.
Mr. Mdonswa, before we go to the District 6 issue of yesterday, what I want to know is how different will these claims, this process be from the process of 1994?
In 1994, the country didn't have experience in dealing with such matters. So over the last 20 years, we have learned a lot as a government in terms of how to process claims. The studies that the professor and many others, including government itself, that have been done have revealed challenges in the past 20 years. So we have learned from those challenges. The way in which we are going to be managing these claims that are now currently being lodged is very different compared to how we managed them in the past. In the past, you had a situation where people could obtain forms anywhere, complete those forms, and then send them to any government department. Information got lost. People did not provide the required information for claims.
But we still had a land commission.
Yes, the Land Commission was there. At the time, particularly in its early stages, it literally comprised of a few individuals. Nowadays, we have an electronic system People will come to our offices to lodge their claims. We will send mobile lodgement units to areas that are far from our offices. We have a 5-year period within which to educate South Africans about restitution and to collect their claims. So this time around, we are more prepared. We have learned from some of the mistakes that were made in the last 20 years, and there are more than enough studies that have pointed out those mistakes that we have learned from.
But that should have been a very fascinating story that drove you to write a book about land restitution in South Africa.
Yeah. And I think it is also important to note that South Africa is, this kind of second round of restitution is not atypical. After World War II, several European countries also did restitution programs, and they had a round 2 of restitution, Netherlands being one of them. So the fact that South Africa is in round 2 is quite, it's quite within the norm, I should say.
Well, we'll continue with our discussion here on rights and recourse, especially on this issue of land restitution. If you want to be part of us, you can join us by calling us on 714-5497 or 5498, or tweet us at Rights Recourse. I'll be back after the break. Welcome back to Rights and Recourse. We're discussing land redistribution. As we already said, that this is a very topical topic. If it is a constitutional imperative that there must be redistribution of land or land restitution, why did we have a cutoff date?
Well, I can start that answer. I believe there is, I think the real answer is it was a political compromise, right? But I'm going to give you the technical legal answer. But I want you to keep in mind that at the end of the day, it was a political compromise. South Africa was formed as a nation in 1910. In 1913 is the first time this newly formed nation passed a piece of legislation to dispossess blacks. That was the Native Land Act. And so this current sovereign that started in 1910 is responsible for the dispossessions that occurred while it was the sovereign of the nation. Anyone dispossessed before 1910 must go and get restitution from the sovereign in power at that time, which was the Queen. And so that's the technical legal explanation as to why, why 1913 is the cutoff, from 1913 to 1994. That's the first one. The second cutoff date was 1998, December 31st, 1998. The reason why we have that second cutoff date is, in fact, because it made claims more manageable, right? So once you have a cutoff date, you had just under 80,000 claims filed. You can make a plan to move forward. Any person whose land was under claim would be put on notice, and markets could adjust. When you have an ongoing open-ended restitution program with no cutoff or no deadline, markets, the uncertainty unsettles markets. So that's the reason for that second cutoff date, the 1998 December 31st date.
Before I go to my next question, let us take this call. Hello, good afternoon, and welcome to Rights and Recourse. Hello, is a caller there?
Good day.
Okay, hi, good afternoon, and welcome.
Good day, sir.
What's your question?
Yes, I just want to find out if it is possible for those people who were forcefully removed from their houses as well to can lodge their claims, or is it only for the land?
Well, I would want to believe Mr. Donzo is here to respond to that question, but I want you, before you respond to that question, how, I've already asked the question, how different. Can people make claims for land that was they never made claims for beyond 1913?
The right to restitution starts from 1913, as the professor has set out. From 1913 all the way, including yesterday, by the way, people can then lodge claims from 1913 onwards. Before 1913, people have again come to government to say that some of us lost land, particularly the Khoi and San. By 1913, almost all of the land that they used to occupy had already been taken. So government is working with the Khoi and San communities, working with broader South Africans to develop what we call an exceptions program. An exceptions program is a program that is going to then provide redress when land was taken before 1913. It is a threefold program. It will address issues of the land dispossessions of the Khoi and San communities, heritage sites, and historical landmarks.
Let me go back. Let me understand you clearly. Are you saying government is working on a separate tract regarding land restitution with the Khoi and the San?
Okay. Government has a land reform program. It has 4 pillars. Land restitution, which is what we are discussing today, land redistribution, which allows any person who would like to use land, they can come to the Department of Rural Development and Land Reform, and land would be made available. Land tenure reform, which deals with people already occupying land but whose tenure is not secure. And then the fourth one is land development, where all beneficiaries of the land reform program and people who have acquired land through the normal market can then come to government to get assistance. The exceptions program is going to be part of the government's redistribution program. Restitution, the professor has already said, had a cutoff date because restitution is a project. It was always meant to be a project, something that in the reconstruction and development program, it was meant to run only for a period of 5 years. But since people were left out, deserving people were left out, government has now decided to open it up for 5 years for people to lodge. Now, the exceptions program is still within government's land reform program, and it is aimed at addressing land issues for the Khoi and San communities, heritage sites and historical landmarks, and that will cover the period before 1930.
I would like to pursue this question around the Khoi and the San, around what the exception that government is looking at, is the overture government is making to them. But Professor, you wanted to say something.
Yeah, I think it's also, this show is called Rights and Recourse, so I think it's important to talk about the Constitution. So Section 25 of the South African Constitution is the property clause. And the property clause, in the Constitution, we have the land, Tammy correctly stated, there's 3 prongs to land reform: land restitution, land redistribution, and land tenure reform. Those 3 are in the Constitution, Section 25. This fourth
program that is now what you're calling the exceptions program is new. It's not necessarily it's not mandated by the Constitution. I believe this is something. This is the first time I'm hearing about the exceptions program, but you can tell us more about it. But to make it clear, this exceptions program is not coming from Section 25 of the. It's not mandated, I should say, by Section 25 of the Constitution.
Toby, before we go too far, I think you respond to that question we came with the telephone call we got. He was asking whether is this going to take care of forced removals too, or is it only going to look at land?
The Restitution Act addresses dispossessions of rights in land. So a person who was removed from a house had a right in land, so they will be able to claim, because a house is located on a piece of land. This
issue you dealt with yesterday in Cape Town around District 6 is a similar issue as the call hours.
That is a perfect example. The people in District 6 were removed because of the implementation of the Group Areas Act. District 6 was declared as an area for exclusive occupation by white people, and people who were not white were then removed. Houses were demolished, and now about 2,000 of them lodged claims in the first period that we had up to 1998, and 1,500 of them said they wanted to go back to District 6. So government has been working. National government, the province, and the city of Cape Town has been working together to restore and reconstruct District 6. To date, we have built 300 houses, and 300 families have been restored back to the land, and Minister has now just recently launched another phase, which is going to be a reconstruction of 150 new houses.
I know Professor Bernadette is burning to come in here, but the question I want to know is how many other places are bumbling along like District 6, because District 6 is becoming a long way.
Alexandra in Johannesburg, Cato Manor in Durban, in all of the major cities. When government, the apartheid government, had introduced the Group Areas Act, providing for separate development, people who found themselves in areas that had not been set aside for them were then affected by the dispossessions.
Professor, you wanted to come in at some stage in that discussion.
And just a more direct response to the caller, what it actually, the Constitution says is anyone who was, any individual or community who was dispossessed of any right in land after 1913 is entitled, as a result of a racially discriminatory law or process, is entitled to an equitable remedy. And the way that right in land has been defined includes not only people with full ownership, what we call fee simple ownership, but also people who had tenancies, labor tenancies. And so it's, when you talk about a right in land, it's very expansive, and so many people have a right to claim from the restitution process, not just those who were former owners. And that's a really important point about the restitution program, because otherwise what you're doing is just reimposing hierarchies of the past, right? Only those who were owners in the past get something now. So it's really important that expansive definition of rights in land, including tenants as well, is important for not, again, reasserting kind of hierarchies that were, existing in the past.
Tommy, I just want to be clear around this 1913, this claim beyond 1913, because I think I read somewhere this week that the commissioners were saying you can't claim beyond 1913. You can only claim from 1913 and coming forward.
Yes. That is because the Constitution in Section 25(7) specifically provides that you can only claim from 1913. Now,
Section 25, subsection 7.
Yes. What we are saying is, now there is then from 25(7), that cutoff date from which people could claim. We are now introducing an exceptions program, which is now going to make an exception so that we can accommodate the descendants of the Khoi and the San, heritage sites and historical landmarks beyond 1913. It is a perfectly constitutional program that we are introducing. The minister is already empowered by current legislation to acquire any land anywhere in the country and give it to any beneficiary, and that is what we are building on. So it's not going to be part of the restitution program, which starts from 1913, but it is going to be part of redistribution. We will be redistributing land to the descendants of the Khoi and the San.
Tell me, what if the Khoi and the San claim the whole of South Africa? Because historically, we are told that they own the whole of South Africa.
We have had engagements with the Khoi and San communities.
Let's hold that response. Let's take this call. Caller is gone. You can continue.
Okay. We have the exceptions program was in fact announced by the president in the State of the Nation address in 2012. Where he said that there would be exceptions to the 1913 Natives Land Cut-off date for land claims to accommodate the descendants of the Khoi and the San heritage sites and historical landmarks. So the department then immediately started on a process of engaging Khoi and San communities. And in 2013, we brought them together for the first time, the Khoi and San communities in Kimberley. We had a conference. We engaged them on the land question insofar as it relates to them. They then established a reference group. We've been working through that reference group, identifying options. We have looked at, for instance, some people said remove 1913, and we considered that. We got legal advice, and we were advised that, particularly on this issue of South Africa only becoming a sovereign country in 1910, that you won't be able to hold the country responsible for things that were done before it was even established.
Let's take Thomas on the line. Thomas, good afternoon and welcome to Rights and Recourse.
Good afternoon, sir.
Yes, what's your question, Thomas?
Sir, I just want to know, my grandfather had a land which he was just farming all along. And now, what I want to know, and that land is under a chief. And my grandfather has passed away, and my father also has passed away. Now, I just want to know if there is any way that I can secure that land so that it can be used by us, meaning the grandchildren of the old man, or the children of the old man, just to secure so that it can be used by us under a certain chief.
Okay, Thomas, we'll answer your question when we come back from the break. If you want to phone us like Thomas did, you can join us on 011 714 5497 or 5498, or talk to us on Twitter at Rights and Recourse. We'll be back after the break.
An historic gathering of 350 rural communities, farm worker and labor tenant rights were high on the agenda. tabled in the list of demands around access to land and security of tenure. The Land Restitution Bill in the interim constitution also came under the spotlight. At best, the bill is vague about securing the land rights, if there should be any, of labour tenants and farm workers. This is small comfort for the labour tenant communities already dispossessed of their farm homes or presently under threat of eviction. And of these, there are many. 20 kilometres outside Vryheid stands a dismal dumping ground for evicted labour tenants, Nkongolwane, stark testimony to a past legal system where the scales of justice were severely out of balance.
Well, they are some of the topic that we're discussing here today. Some of the things we're talking about, I think that answers Thomas's question halfway. But Thomas asked a very important and pertinent question. And that question is, his grandfather owned some land, and this land was under a chief. I understand that government regards traditional leaders as custodians of the land. How does Thomas get back the land that was owned by his grandfather?
Okay. Firstly, the institution of traditional leadership is recognized by the Constitution, but the recognition is subject to the provisions of the Constitution. So the institution as a whole would then be subjected to what is contained in the Bill of Rights. Now, to answer Thomas's question, we would have to look at whether the land that he's talking about is individual land. In other words, it was owned by his grandfather, he had a permission to occupy, a title deed or not. If he did not have any of those documents, then it would be communal land. Then if they want to claim back that land as a community, including Inkosi there or their traditional leader, they would then have to call a meeting, take a resolution authorizing one of them to go to the commission and lodge a claim on behalf of the community, because the Constitution says a person or a community can lodge a claim.
But Thomas would ask you the question, why should he go to an Imbizo to get a resolution before he can claim his grandfather's land?
If the grandfather had his own individual rights on the land, he then doesn't have to go to an Imbizo. He will go to an Imbizo, a community gathering, because he would then be claiming communal land. The land belonged to the community if it was not privately owned by his grandfather.
But Tommy, that assumes that the leadership is always clear. Which traditional leader do you go to? The ones put in by the apartheid authorities or the ones that were there before? I mean, there's never, so to say he must go to, the leader must file the claim, there's a question of who's the leader?
The courts have interpreted what is meant by community in this context, and they've made it very clear that traditional leadership is an important factor that would have held the community together, but it does not necessarily have to be there. So what you need to do to lodge a claim for a community is to call that Imbizo, to call the community together and say, we lost this land, there is this opportunity for now collectively to get the land back, must we go ahead? And then the community will take a resolution saying, let us lodge the claim and then authorize someone. A traditional leader, if they are present, is always welcome, and a traditional leader can on their own go and call the community and lodge a claim. But when they do come, even traditional leaders, when they come and lodge claims on behalf of communities, Section 10 of the Restitution Act requires that they must also have a resolution of those people that lost land, authorizing him or her to lodge a claim.
Tommy, earlier we spoke about the exception, I don't know if you call it a rule. Exceptions program,
yes,
that regarding the Khoi and the San. And Professor, you wanted to weigh in on that, but first of all, I want to ask this question. There's this huge claim that's been made by King Zwelithini in Natal and some parts of the Eastern Cape. What happens to that claim? Did he make a claim, first of all?
We have not received that claim. And once we have received it, then we'll be able to see why the King has lodged a claim in respect of what the media has reported on. The media has, we've read in the media that the claim is based on dispossessions that took place in the 1860s. And the Constitution says for you to claim restitution, you must have lost your land after 1913. And the Restitution Act is very specific when it comes to the requirements that must be met. So for an example, if a claim is lodged by Uhlangalezwe on behalf of the Zulu nation, it would have to then be within what is defined as a community. And like I said, even the Constitutional Court has given us very clear guidelines about what a community is. We have taken a stance that we've heard about these claims in the media. They have not been lodged with the Commission, so we cannot comment on them until we receive them.
Lodged.
Yes. When they are lodged, then we will get further details about the claims, and then we'll be able to then process them.
Professor, you wanted to have weigh in on the exceptions programs, which is the last part on this issue, so that we can go to something else.
Yeah, the exceptions program. First, I want to make clear that what I'm saying is that the exceptions program is not mandated by the Constitution. I'm in no way saying that it's unconstitutional. So that's the first clarification. But once you move away
Somebody
from,
might be writing that down.
that's good. Once you move away from the 1913 date, which this exceptions program is doing, things get very messy. Tommy's talking about consultation with the Khoisan, but Shaka was a conqueror. So what about the people conquered by Shaka? Why just the Khoisan? Once you open the gates, you've opened the gates. And so it's not just the Khoisan who were conquered, who have claims before 1913. And so the exceptions program is making things messy. And I just want to know how the Commission intends to deal with this messiness, because it's absolutely not just the Khoisan when you open that 1913 gate.
Can you respond to that?
Let's make an example of what this exceptions program is all about. In the Eastern Cape, there were frontier wars, the so-called 100-year wars, and there were 9 of them. Now, during the 4th War of Dispossession, there was a chief Ndlambe who ruled land. There was a leader of Dutch troops that wanted to invade land by the name of Stockestrom.
Stockestrom was a magistrate in Graafrenet.
That would be the ascendants of that Stockestrom. Now, Ndlambe had warriors, and those warriors were Xhosa warriors, they were Khoi warriors. It was a Khoi warrior that killed Stockestrom on a particular piece of land in Zierberg in the Eastern Cape. So as part of the exceptions program, we have bought 45 hectares of land where we are going to erect a memorial for the Xhosa, for the Dutch, and for the Khoi and San. When the minister calls them to a meeting, they go there, they all pray together. Because this area is so important to them. So through the exceptions program, we are saying there are thousands of areas like that in the country where the land could have been taken before 1913, and we are using our redistribution program to then acquire this land, and then it must benefit the Khoi and San communities, the Dutch community in this particular case, and the Xhosa communities. And there is another one that we are doing also in Wellington, in the Western Cape. Yes.
You said it must benefit the Dutch community as well.
Yes.
Oh, my word.
We are building. It's an interesting thing, really. I would like to really hone in on these exceptions. I want to move on to something else. There are those, Tommy would say, that the restoration of land to claimants threatens food security, as many of the farms are lying dormant, nobody's using them, people are given farms and nothing happens on these farms.
In the year 2010, when the previous administration had taken over and government had established a new Department of Rural Development and Land Reform, we conducted a study looking at land reform farms and their status. And we discovered that at the time, approximately 90 of them were in distress. And government's response was then...
How many? 90?
90% of them
90% were in distress.
And then what we did
Probably you should explain what you mean by distress.
They being in distress meant they were not producing.
Not being productive.
Yes, they were not being productive.
And that's exactly what a lot of people are complaining about.
Yes. And then what we did was we introduced a new program, this 4th pillar now, of the land reform program, which is land development. We've got, it's been implemented through a recapitalization and development policy that we have, which allows us to then go and assist beneficiaries of land reform and also other people that have, out of their own savings, gone and acquired farms. More than 2,000 of those farms have been brought back to full production. We have spent in excess of 2 billion providing that assistance. We have revamped our program for assisting beneficiaries. In the past, for instance, for every rand that we spent acquiring land, we would provide a maximum of 25 cents. So only 25% of the value of the land that we bought was made available. Now we fund up to 100% of the business plan for the farm so that it can continue. But we provide funding for a period of 5 years, and after 5 years, then farms are sustainable, and that is how we are dealing with some of those challenges relating to production.
That's all interesting, but I never heard you say we take the people through a training process.
The strategy for development is strategic partnerships. Strategic partnerships, no one through recapitalization and development gets funding unless they have a strategic partner. So if you are a skilled farmer, you have experience, you know what you are doing, the department will then provide you with a mentor that is going to assist. Just come a few hours a week to just make sure that you are doing things correctly. Then we have share equity. We have core management and many other examples of partnerships. And through these partnerships, then there is a skills exchange program that takes place.
But in your book, you talk about why is the land restitution program important for South Africa and the rest of the world. Could you give us some insights?
Absolutely. But before I go there, can I just actually respond directly to Tommy, what he just said about the strategic partnerships? One of the communities I work with is called the Popela community. And that might be familiar to many people because they won a constitutional court judgment, it's about 6 to 7 years ago, where the constitutional court said they must be reinstated their land. They, to this day, have not received their land. What's going on? Part of what the commission was doing is trying to, as Tommy was talking about, form a strategic partnership with the current owners of the land. But the community didn't want that strategic partnership. Why? Because these were the same farmers who were abusing them, throwing them off of the land. They weren't giving them access to the gates to access their graves. These are the very same farmers that they were at war with, and the commission was expecting them to then form a partnership with this existing landowner to kind of move forward. So I think that these strategic partnerships are, can sometimes work, and I think when they work, I think they're powerful, but they also sometimes don't work, like in the case of the Popela community who I'm working with. So I think we need to kind of keep that front and center in our minds as well. Strategic partnerships aren't a cure-all.
There's a reported case study in the Western Cape around these strategic partnerships where a farmer who is a doctor by profession has put all of his people together and gave them part of the land.
Yes, that would be part of what we call a share equity scheme. We have now to address another challenge. In South Africa, we have in excess of 3 million people living on commercial farmland. And those people have been living and working on the farms for many years. But their tenure is insecure because they live on someone else's land. So there is a proposal as part of our land tenure program of strengthening the relative rights of these people who are working the land. The media calls it the 50-50, where the proposal is that half of the property must be acquired by government and given to farm workers that have been working the land for more than 50 years. But where the challenge then comes is that our proposal as government is that the compensation for the 50% that gets taken will be deposited into a development trust to develop all of the land and not be given to the farmer. So as a result, there's been a lot of discussion and debate through the media, and now the department is convening a land summit, a land tenure summit that is going to be discussing tenure issues, including this one. On the previous issue of partnerships, we do not impose as government a particular partner to communities. The previous owner, if they were farming successfully, is then most of the time the preferred person, but we are working through committees, district land reform committees, which we are establishing, which are going to advise us whether farmers actually know what they are doing, whether this farmer that we bought or whether this person that we want to bring in as a strategic partner is in fact the best person for the job. So the National Development Plan says government must establish district land reform committees. We are piloting those committees now in the Western Cape and in KwaZulu-Natal. And when we implement land reform, we will do it through these committees.
We'll come back to that. Join us today. If you want to join today's discussion, you can call us on 011 714 5497 or 5498, or tweet us at Rights and Recourse. We'll be back after the break.
The late Mhlaba was a stalwart leader in the ANC and is remembered as one of the leaders who steered the cause of the liberation struggle. Rural Development Minister Gugile Nkwinti reminded the gathering that Mhlaba was verbal when it came to land. He saw it as vital in the development and integration of South Africa.
We have simplified land reform into 4 functions or pillars, namely restitution of land rights, land redistribution, land tenure reform, and land development. The principles underlying land reform, as set out in the Green Paper on Land Reform, are firstly, deracializing the rural economy, secondly, democratizing the allocation and use of land across gender, race and class, and finally, sustained production discipline for food security.
Mhlaba wanted nothing more than to restore the dignity of black South Africans. Mhlaba, as the first premier of the Eastern Cape, saw that by giving people land and emerging farmers an opportunity, the country would head to an equal future.
Our ideological platform is the Freedom Charter, particularly clauses 3 and 4. The people shall share in the country's wealth, and the land shall be shared among those who work it.
Leaders such as Omre set the tone of what leadership is and what direction the country should be going.
Welcome back. The Minister of Rural Development, Mr. Gugile Nkwinti, confirming what Mr. Tamin Donso was telling us earlier. But he threw in another caveat. Across gender, women must own land.
That is correct. And because of this 4-pillared program, we are able to control how women benefit better in the redistribution program. In restitution, because it's rights-based, we give land to those who lost it, regardless of gender. We have...
Initially, even though, I think this is a step in the right direction, because in the old days, traditionally, women were the workers of the land.
Yes, that is correct. They were the workers of the land, and the minister has just referred to clauses 3 and 4 of the Freedom Charter, saying that the land must be shared among those who work it. So when women work the land, then they must get the land. You'll recall former President Nelson Mandela said, if you do not recognize women, you do not empower and emancipate them, then more than 50% of the population would then not be used. So in our program, we always make sure that we distribute land to the women. We have, since 1994, in the restitution program, for instance, 371,000 households have benefited. 137,000 of those are female-headed households.
One more question I wanted to ask you quickly is, there's been questions around what kind of budget would be needed to make this viable, a reality? Or are we throwing money into a bottomless pit?
We are not. The question that I always have in my mind every time I hear the issue of budget is, what are the costs of not doing it? Government has given us, just for restitution only, a budget of 9 billion rands over the next 3 financial years. When the President signed the Restitution of Land Rights Amendment Act, the Minister of Finance informed Parliament that government would review the funding framework for restitution. So we are hoping that over the next MTF period, we are then going to be receiving higher allocation than what we have.
Professor Benedict Atueni, we are hoping to have somebody from Zimbabwe to give us a perspective as to how different is the South African land restitution program to that of Zimbabwe. What lessons can be learned in the South African situation?
Well, the first question you asked is, what are the differences? And I think that the main difference is South Africa is where they're using legal channels to redistribute the land, kind of doing it by the books. But the point is, as Tommy was saying earlier, there are costs if it's not gotten right. Professor Jim Gibson of the University of Washington, St. Louis, did one of the most robust quantitative studies on land reform. He interviewed 3,700 South Africans, and he found that 85% of respondents agreed with the statement most whites stole the land and have no right to the land. And more troubling, 1 out of every 3 respondents agreed with the statement, we need our land back no matter what the consequences are for the political stability of the nation. So those of us who work on land, we know this kind of issue is a potential time bomb waiting to explode, but this study by Professor Jim Gibson gives empirical confirmation to that kind of gut feeling of people on the ground. And so Tommy is exactly right when he says that when your question to him was, can we afford this? And Tommy's response to you is that we can't afford not to do this. I think that's exactly the right response.
Yes. Tommy, the other thing that many people are talking about, rural claims are hardest to resolve, while claims covering urban areas can often be settled fairly squarely. How many of the people who have claimed land have decided to rather take the money than the land?
To date, we have settled more than 77,600 claims. 72,000 of those have been people opting for financial compensation. Now, that's an indication of many things. The first being, and the most obvious, the land in urban centers is developed. It is not restorable, but it is also an indication of the fact that in our society there are not that many sources of income. So people will then see proceeds to a claim as a source of income coming into the household. Some of the studies, including this one, have looked at what is the money, what does the money get used for? And I remember one of our former deputy ministers would say some of the money is invested in cemeteries, because people would then go remember the people that lost land and then honor their memory by erecting a tombstone on their grave. Other people use the money to just deal with poverty. We as government have been saying that, particularly in this round, we're encouraging people where land is restorable to accept land, to rather opt for land, because we pay money and then a few months down the line, people come back to government wanting those government grants.
Yeah. The other question I want to ask quickly, sorry, Professor, the question I want to ask quickly, you can both answer this question because we're going to the end of the program, quickly running out of time, and there's a lot to discuss still. What has been, we heard about the Khoisan, you've consulted Khoisan. What is the farming community saying? What is Agri-SA saying?
Our approach to consultation has been one where the minister has been very open. He established, we wanted to align policies of land affairs with the new mandate for rural development and land reform. Then we published a green paper which contained policy proposals. So since September 2011, we've been consulting extensively through a national reference group, which is a group that has all stakeholders, land reform stakeholders, including organized agriculture. So the views of all stakeholders, organized agriculture, are part of all the policies and implementation models that we have.
And I'd like to point out, Tommy was just talking about...
Let's make that your final comments.
Good, yeah. One of the fundamental inequalities of the land restitution program is that, as Tommy was saying, the majority of people have been settled with financial compensation. And this financial compensation is not tied to the market value of the properties lost. Instead, it's symbolic. But the point is, when former owners, when black people were dispossessed by the apartheid and colonial governments, they get symbolic compensation not tied to the market value of the land. But when current owners are, the property is expropriated to give it back to communities, they get market value. Right? And so that's the fundamental injustice, is prior owners who are mostly black get symbolic compensation, where current owners who are mostly white get market value. To correct this asymmetry, to correct this injustice, you must either give both groups symbolic compensation or both groups market-related compensation. You cannot give one group one and another. So that'll be my final comment and criticism of the restitution program that needs to be addressed in round 2.
Tommy, final word from you.
To address the issue of compensation, we have, and as part of reviewing the willing buyer, willing seller model, on the same day that the President signed the Restitution Amendment, he also signed the Property Valuation Act. That act will establish an Office of the Valuer General. It will then assist government to codify Section 25(3) of the Constitution.
The Valuer General will look at land that is being sold, but there's been a talk, something quickly, around the issue of government-owned land.
Yes, government also owns land. About 17% of the land in South Africa is owned by the state. When that land is given to people, then we do not pay for it. It is given for free. But what the Valuer General will do is it will give more detail to really what is meant by just and equitable compensation. That will then deal with the amount of compensation that get paid for land. But what we have done for those who want a restitution through financial compensation is that we have reviewed our policy. We've learned from the recommendations that have been made, and we have reviewed our format.
Well, a lot still has to be said around this issue of land restitution here in South Africa. Land policy issues are complex, country-specific, of a long-term nature, and often controversial politically. Even though specific interventions in the land policy area can make society better off, such measures may be challenged by vested interests that derive benefits from the status quo. To prevent a stalemate or inaction, proper sequencing of reforms and attention to their political economy will be critical. This has been Rights and Recourse. This program is repeated at 10 tonight and at 5 on Monday morning. A big thank you to our guests, Professor Bernadette Atuahene and Mr. Mdonzwa here. And from all of us in the studio, have a good afternoon.